dear students, today we are going to discuss an important principle that's known as principle of absolute liability. Dear learners, we are all aware about this fact that a person who commits tort is an independent tort freezer and his liability is called independent liability. When a person joins others in committing tort with a common intention, the liability is called joint liability. When one person is made liable for the torts committed by another one, the liability is called vicarious liability. Now, sometimes liability in tort may arise subject to proof of negligence. If the negligence is proved on the part of defendant, the wrongdoer, he/she is liable. If the negligence on the part of the defendant is not proved, he/she is not liable. In other words, whether the defendant is to be held liable or not is to be decided subject to the proof of negligence while committing the wrong on the part of defendant. However, there are certain circumstances in which the defendant is held liable in tort irrespective of proof of negligence. For instance, the rule of res ipsa loquitur, which means the thing tells its own story or the thing speaks for itself. And one such liability arises which is known as strict liability. The strict liability is that liability in respect of which the defendant is held liable in tort, although there is no negligence on his or her part. In other words, liability imposed on the defendant irrespective of negligence on his part is called strict liability. In case of strict liability, certain defenses, for instance, act of God, malicious act of stranger, plaintiff's own fault, and so others, can be invoked so as to enable the defendant to get exempted from liability in tort. This strict liability was coined for the first time by Justice Blackburn in year 1868 in the famous case of Rylands versus Fletcher. Justice Blackburn evolved the rule of strict liability on the basis of one of the principles, which means that everyone must use his own land so not to damage another. According to this rule, any person who for his own purpose brings on his land and collects there, keeps there anything likely to cause mischief if it escapes, must keep this at his own peril, and he is prima facie answerable for all the damage which is the natural consequences of this escape. If the defense under the strict liability are discarded and the defendant is put without providing him an opportunity to plead any defense, such liability is called absolute liability. And this absolute liability was coined for the very first time in year 1987 by the then Chief Justice of India, Justice P.N. Bhagwati. There are two leading cases of poisonous gas disaster which led to the creation of principle of absolute liability. Number one, Union Carbide Corporation versus Union of India. This case is popularly known as Bhopal gas tragedy. And another landmark decision which resulted in the evolution of principle of absolute liability is M.C Mehta versus Shri Ram Foods and Fertilizers, popularly known as Oleum gas leak case. The facts of the cases are: on the midnight of 2nd of December 1984, there was a leakage of poisonous gas named as methyl isocyanate from Union Carbide Corporation India Limited, which was located at Bhopal, Madhya Pradesh, and at the same time it is a subsidiary of Union Carbide Corporation, United States of America. This disaster was described as the world's worst industrial disaster as it claimed the lives of 3,000 people and causing serious injuries with a variety of complications to about 6 lakh people. The Government of India proclaimed an ordinance called the Bhopal Gas Leak Disaster Processing of Claims Act 1985 and filed on behalf of the victim a suit in the United States District Court, New York. Similarly, several petitions were filed by the victims of legal representatives of the deceased. The United States District Court dismissed all the petitions on the ground of forum non-convenience, which means that this is not the appropriate form for institution of this suit. The Union of India preferred an appeal before the United States of Appeals for Second Circuit, and the same was dismissed. Then, Union of India filed a suit titled Union Carbide Corporation versus Union of India in year 1991 in the District Court of Bhopal, Madhya Pradesh in India. And it claimed $3.3 billion equivalent to 3,900 crores as compensation. The district court ordered Union Carbide Corporation to pay an interim relief of $270 million equivalent to 350 crore Indian rupees to the victims. The Union Carbide Corporation filed a civil revision petition before High Court of Madhya Pradesh, which reduced the amount from 350 crores to 250 crores. The Union Carbide Corporation was reported to have decided to go on appeal against the interim relief and devising a new strategy out of maneuvering the Indian government by direct settlement with the gas victims. Against the move by the Union Carbide Corporation at the plea of Union of India, the District Sessions Court, Bhopal, passed an interim order directing Union Carbide Corporation not to make any compromise or settlement with any individual until further orders. Later, both the parties preferred appeal before the Supreme Court on different issues, which included several municipal and international ones, which were invoked in Bhopal gas leak disaster case. And one such important issue is the liability of the parent company, that is Union Carbide Corporation, for the torts of its subsidiary company abroad. The Union Carbide Corporation has maintained consistently that it is only morally but not legally liable. The parent company, that is Union Carbide Corporation, evidently was trying to escape from liability. The other issues involved is the responsibility of home state, that is USA, for the hazardous activities of United Carbide Corporation, that is subsidiary abroad in India. Another issue is with regard to the responsibility of the host state, that is India, in enforcing what? The safety standards for the protection of life and environment and the extent of liability to the victims for their rehabilitation in the event of accidents. While the case was pending before the Supreme Court, one more gas tragedy within a short span of time took place in Shri Ram Foods and Fertilizers factory, resulting in death of an advocate and injuries to several others. This case drew attention of Supreme Court headed by the then Chief Justice of India, who coined the principle of absolute liability, keeping in mind one-year-old Bhopal gas disaster case. After a long-drawn litigation over a period of 4 years, a final settlement arrived at between Union of India and Union Carbide Corporation in terms thereof. The Supreme Court in Union Carbide Corporation versus Union of India passed an order on February 14th and 15th in year 1989, directing the payment of a sum of $470 million or its equivalent nearly about 750 crores. The Supreme Court, while passing an order dated 14th of February 1989 directed Union Carbide Corporation to pay $470 million equivalent to 750 crores approximately towards the compensation to the victims as full and final settlement in satisfaction of all past, present, future claims, and the same was accepted by both the parties, that is Union Carbide Corporation and Union of India. The entire amount had to be paid and was really paid by March 31st, 1989. The court, by exercising its extraordinary jurisdiction, quashed all proceedings, civil, criminal or contempt of court, and so many against the Union Carbide Corporation. The court also stressed the need to evolve a national policy to protect national interests from such ultra-hazardous pursuits of economic gain. In M.C Mehta versus Shri Ram Foods and Fertilizers, this case, as I said to you, that it is popularly known as Oleum gas leak disaster case. The facts of the case were that Shri Ram Food and Fertilizers is a subsidiary of Delhi Cloth Mills Limited, which is located at a thickly populated area of Delhi. On 4th of December 1985, there was a leakage of oleum gas from the sulfuric acid plant, resulting in the death of an advocate who was practicing in Tees Hazari Court, and injuries to several others. On 6th of December 1985, there was a minor leakage again from the same plant. Against a complaint under section 133 of Code of Criminal Procedure, the District Magistrate Delhi directed the management of Shri Ram Foods and Fertilizer Industries to close down the unit and to show cause and reason within 7 days from this order. The petitioner, M.C Mehta, an advocate in Supreme Court, filed public interest litigation in the Supreme Court under Article 32 of Constitution of India. The petitioner in his petition requested the court to direct the government to take necessary steps to avoid such leakages from the industries engaged in dangerous and hazardous manufacturing processes. He also reminded the court the one-year-old great gas disaster from Union Carbide India Limited, Bhopal, and prayed the court to direct the management of Shri Ram Foods and Fertilizer Industries to shift and relocate the plant at a place far away from the city. Certain issues were raised and the principles were formulated. The Supreme Court and the Lieutenant Governor Delhi appointed 2 committees separately to inspect the plant and submit the report on certain issues, which included: number 1, whether the plant can be allowed to continue or not; number 2, if the plant is allowed to continue, what measures are required to be taken to prevent leakages, explosions, air and water pollution; number 3, to find out the number of safety devices existing in the plant and others, though necessary, are not installed in the plant. The 2 committees inspected the plant and submitted the reports with necessary recommendations. The Supreme Court, basing on the report, decided to permit Shri Ram Foods and Fertilizers to restore its operations. Although such industries are very dangerous, they are very essential for the progress and economic development. The court laid down certain principles. Number 1, the management of Shri Ram Foods was required to deposit in the court 20 lakh rupees as security for the payment of compensation to the victims. Further, the management was required to furnish a bank guarantee of rupees 15 lakh, which shall be encashed by Registrar of Supreme Court wholly or partially in the event of gas leakage, if any, in the ensuing 3 years. The management must comply with the recommendations of the expert committee an amount of 30,000 should be deposited with the court for travelling expenses of the expert committee members. The management of Shri Ram Foods and Managing Director of Delhi Cloth Mills Limited should execute a written undertaking to pay compensation to the victims as a consequence of gas leakage or other event in future. A green belt of 1 to 5 kilometers width around such industries should be provided. The court appreciated the petitioner M.C Mehta for filing number of public interest litigations, and this petition in particular. The court ordered Shri Ram Foods to pay 10,000 towards the cost. The court directed the central government to set up an environmental court consisting of a judge and 2 experts, ecological science research experts, as members to assist the judge in deciding the environmental cases. Pursuant upon the recommendations, the Government of India passed the National Environment Tribunal Act 1995 to deal with the cases of environmental pollution. The Supreme Court observed that the rule of strict liability evolved in Rylands versus Fletcher if applied to this situation. Then those who had established hazardous and inherently dangerous industries in and around a thickly populated areas could escape the liability for the havoc caused thereby, pleading some exceptions to the rule which is laid down in Rylands versus Fletcher. For instance, when the escape of the dangerous substance which caused the damage was due to the act of stranger, say due to the sabotage, or there is no liability under that rule. The Supreme Court then took a bold decision holding that it was not bound to follow the 19th century rule of English law, and it possesses the power to evolve a rule which is suitable to the social and the economic conditions prevailing in India the present day. It evolved the rule of absolute liability as part of Indian law in preference to the rule of strict liability evolved in Ryland versus Fletcher. It expressly declared that new rule was not subject to any of the exceptions under the rule laid down in Ryland versus Fletcher. After evolving the rule of absolute liability, the court directed the organizations who had filed the petition may file actions in appropriate court within a period of 2 months to claim compensation on behalf of the victims of gas leak. Chief Justice P.N. Bhagwati observed in this context, the rule laid down in Rylands versus Fletcher, which is evolved in 19th century at a time when all these developments of science and technology had not taken place, cannot afford a guidance in evolving any standard of liability consistent with the constitutional norms and the need of the present day economy and social structure. We do not feel inhibited by this rule, which was evolved in the context of a totally different kind of economy. Law has to grow in order to satisfy the needs of the fast changing society and keep abreast with the economic developments taking place in the country. As new situations arise, the law has to evolve in order to meet the challenges of such new situations. Law cannot allow the judicial thinking to be constrained by reference to the laws it prevails in England or for that matter in any other foreign legal order. We in India cannot hold our hands back, and I venture to evolve this new principle of liability which English courts have not done. The Supreme Court thus evolved a new rule creating absolute liability for the harm caused by the dangerous substances as was hitherto not there. The statement which Chief Justice Bhagwati made is very important, and I quote, "We are of the view that an enterprise which is engaged in hazardous or inherently dangerous industry which poses a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas, owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous activity which it has undertaken. The enterprise is under an obligation to provide that the hazardous or inherently dangerous activity in which it is engaged must be conducted with highest standards of safety, and if any harm results on account of such activity, the enterprise must absolutely be liable to compensate for such harm, and it should be no answer to the enterprise that to say that it has taken all the reasonable care and that the harm has occurred without any negligence on its part. The rule was summed upon in these words that with the assertion that this rule will not be subject to any of the exceptions recognized under rule laid down in Ryland versus Fletcher, we would therefore hold that where an enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of accident in the operation of such hazardous or inherently dangerous activity resulting, for example, in the escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vis-a-vis the tortoise principles of strict liability under the rule of Ryland versus Fletcher. The court gave two reasons justifying the rule. Firstly, the enterprise carrying on such hazardous and inherently dangerous activity for private profit has a social obligation to compensate all those suffering therefrom, and it should absorb such losses as an item of overheads. And secondly, the enterprise alone has the resources to discover and guard against such hazards and dangers. It explained the position in these words that if the enterprise is permitted to carry on hazardous or inherently dangerous activity for its profit, the law must presume that such permission is conditional on the enterprise absorbing the cost of any accident arising on account of such hazardous or inherently dangerous activity as an appropriate item of its overheads. Such hazardous or inherently dangerous activity for private profit can be tolerated only on the condition that enterprise engaged in such hazardous or inherently dangerous activity indemnifies all those who suffer on account of the inherently dangerous activity, regardless of whether it is carried on carefully or not. This principle is also sustainable on the ground that enterprise also has the resource to discover and guard against the hazards or dangers and to provide warning against potential hazard. The court also laid down that the measure of compensation payable should be correlated to the magnitude and capacity of enterprise so that the same can have a deterrent effect. The position was therefore stated in these words, I quote, "We would also like to point out the measure of compensation in the kind of cases referred to must be correlated to the magnitude and capacity of enterprise because such compensation must have a deterrent effect. The larger and more prosperous the enterprise, the greater must be the amount of compensation payable by it for the harm caused on account of an accident in carrying out the hazardous or inherently dangerous activity by the enterprise." To conclude now, my dear students, in this lecture, we tried to understand the principles of absolute liability carved out by the then Chief Justice Bhagwati, making an enterprise absolutely liable which is engaged in carrying out inherently dangerous or hazardous activity. Under this, persons cannot claim any defense so as to avoid the liability or minimize its liability as clearly spelled out by the Supreme Court. It was propounded by the Supreme Court that where an endeavour is occupied with a risky or intrinsically dangerous action, and if any mischief results to anyone because of the calamity in activity, the industry would be held totally and absolutely liable, not allowing to claim or invoke any of the defences which otherwise can be claimed under the doctrine of strict liability. The rule of absolute liability, developed from the rule of strict liability evolved by Justice Blackburn in 1868 in the case of Ryland versus Fletcher. The liability of the defendant under absolute liability is more when compared to the strict liability. Strict liability provides for certain defences to the defendant to get exemption from the liability, whereas the absolute liability provides no defense and the defendant has no chance to escape from the liability. Therefore, the doctrine of absolute liability imposes responsibility, or you can say liability, on the persons irrespective of negligence on their part. With this, we conclude today's topic on the doctrine of absolute liability. Hope you understood it well. Thank you.